Good afternoon. I'm Josh Dunn, and I'm the director of the Center of the Study of Government and the Individual here at UCCS. I'm delighted to welcome you to our very important lecture on this extremely important topic. Currently in CSGI, we're expanding our program offerings to increase our reach and impact in the community. One of our goals is to increase civic understanding, both among students and in the broader community. To do that, we've created the program on the American Constitution, which is part of the Regents Civics Initiative for the University of Colorado. Today's lecture is part of that program. Before introducing our speaker, I did want to let you know that if you have any questions, please use the Q&A button at the bottom of your screen. After the lecture, we will have time for a few questions. Today's lecture will focus on an exceptionally timely but also timeless topic. Freedom of religion is a core commitment of the First Amendment. However, a few areas of constitutional jurisprudence are as controversial and perhaps inscrutable as the Supreme Court's treatment of religion. To help us understand this often fraught topic, I'm delighted to welcome our distinguished speaker, Professor Michael McConnell, one of America's leading constitutional scholars, and in particular, a leading scholar on the religion clauses of the First Amendment. Professor McConnell is Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School. Previously, he served as a circuit judge on the United States Court of Appeals for the 10th Circuit. I do believe this means that he is our first Article III judge to speak for CSGI. He was also a professor at the University of Chicago and University of Utah, and also served as a clerk for Supreme Court Justice William Brennan. The book is The President Who Executive Power Under the Constitution. Now has a forthcoming book directly related to today's event, Agreeing to Disagree, How the Establishment Clause Protects Religious Diversity and Freedom of Conscience. Professor McConnell, thank you so much for joining us. I turn it over to you now.
Thanks. This is a real pleasure. I wish I could be there. And Colorado Springs is one of the world. So you all live in a very nice place. The religion clauses are often in the news. What you read in the newspapers and hear from commentators is, I think, often exaggerated and not very illuminating. And I want to pull back from today's headlines and give a bit of historical perspective, by which in this particular case, although I'm really very interested in the founding, and we could talk about that if you're interested, I'm going to talk about the last 40 years of Supreme Court doctrine, because it's not only about an important subject, but jurisprudentially, it is, I think, unique in that I don't think there is any area of constitutional law in which the Supreme Court has so thoroughly reversed itself, changed its tune over a relatively rapid period of time as with respect to the religion clauses. And when I speak of the religion clauses, I'm going to use the plural. Some people call it singular, but there are two parts of our religious freedom guarantee. The First Amendment says, and I quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." So we have an establishment clause and we have a free exercise clause. Now, at the beginning, those two were thought to be entirely complementary. They were proposed by essentially and advocated by essentially the same people. It never really occurred to anyone, I believe, in American history that they were at war with each other, or as the Supreme Court so frequently says now, in tension with each other. But the court has created doctrine under both of those clauses that has made them, or has created that tension. And I think over the last several decades has begun to unwind that. But I want to begin the story, basically when I was a law clerk. 1980 is when I'm going to start. It's kind of an arbitrary year, but it's an emblematic year. And let me just tell you what the state of play was under both the free exercise and the establishment clauses in 1980, and then bring you up to the present. So the free exercise clause provides, as I quoted before, Congress, and now it extends to the state governments as well. So government cannot pass and enforce laws which prohibit the free exercise of religion. So what this does is it permits us to worship God and carry out our religious duties as we understand them in accordance with conscience, even when that may be unpopular, even when the government may not approve of what we believe in. So, and as of 1980, the Free Exercise Clause was given a quite robust interpretation. This is true. It really began to get that interpretation around the early 1960s. But by 1980, there were unanimous or nearly unanimous decisions, holding that that religious individuals, people with beliefs, had the right not to be coerced into, they had the right to follow their own religious beliefs, even in the face of a contrary law, unless the government could show that enforcement of that law against them would serve what the Supreme Court calls a compelling governmental interest. That's legal jargon, but what that essentially means is unless the government can show that it has a really important reason, not just an ordinary sort of regulatory interest, not just a preference, but actually a very strong, compelling is a very strong word in the legal vocabulary. A couple of cases that just illustrate what that meant. Wisconsin against Yoder involved Amish in Wisconsin, and the Amish believe that children should not go to high school above the age of 14, getting your basic education in literacy and numeracy is enough, and that above that period, that what you mainly get in high school is indoctrination into various aspects of modernity, most of which the Amish people disapprove of. And, that's a pretty strong claim to be able to keep your kids out of school. Today, we would probably call that homeschooling, but homeschooling was not a concept in 1970 when this case came up. Well, the Supreme Court essentially unanimously held that the Amish had a constitutional right under the Free Exercise Clause not to send their children to school above the age of 14. Now, I say almost unanimous because one justice, William Douglas, thought that was the correct interpretation of the Free Exercise Clause, but believed that the free exercise right belonged to the children involved. And so he believed that parents could not invoke that right, but without the active consent of the kids. So basically, it was a right of the Amish children, or teenagers, right, to make the decision, not the parents. But nobody took the position that the Free Exercise Clause did not provide immunity for somebody, whether parents or children, from compliance with this law. And you would think perhaps compulsory education laws are a compelling interest. But what the court said was that when you look at the Amish way of life, that Amish are in fact quite successful, and that the farming, the agricultural and non-technological nature of the Amish way of life was an adequate substitute for schooling. So instead of viewing the question of compelling interest at some high level of abstraction, the court really bore in on what did this mean for the plaintiffs, who were, as I said, Amish families. So that was the result in that case. And it's still a controversial case, but it wasn't very controversial among the 9 justices. Another example, this case actually came up when I was clerking for Justice Brennan, and he joined in the opinion, involved a Jehovah's Witness who was working in a steel plating, and then that company got a contract to provide the steel plating for armaments to be used in the Vietnam War. And I think it was the Vietnam War, although this case didn't come up until 1980. So, it may be a later military conflict. But in any event, Jehovah's Witnesses are pacifists, except in the final war of Armageddon. And so he couldn't work. And so he had to resign his position, and he applied for unemployment compensation, and the state of Indiana said, no, you're not entitled to unemployment compensation because you only got unemployment when you're involuntarily unemployed, and that you have to be available for suitable work. And the state said he had not made himself available, that this work was suitable, and he had not made himself available for it, and so he was not entitled to unemployment compensation. Well, the court almost unanimously, 8-1, this time there's a real dissent, Justice Rehnquist, but 8-1 held that the Jehovah's Witness, his name was Thomas, was entitled to unemployment compensation because the government cannot, under the Free Exercise Clause, declare that an exercise of religious conscience is not suitable. That is, since when you think about unemployment compensation and what jobs you're required to take, physicists are not required to take a job at, flipping hamburgers. People don't have to move more than 50 miles. There are all kinds of reasons you can turn down a particular job. And in light of that, the court held, well, religion is one of the most highly protected bases of choice under our system. And the state of Indiana can't just say, well, religious reasons don't count, that they're not suitable. And so Thomas won, even though there's a general law saying that we only pay unemployment compensation to people who are involuntarily unemployed. So, those are a couple of examples. I hope you remember them, because I'm going to come back and talk about at least the unemployment compensation example again in just a moment. But let's turn to the Establishment Clause. And here the court had, since the late 1940s, been held by what we now know, or at least I think we know. I suspect there are a few historian dissenters out there still, but not very many, I would guess. I'm not really sure about that. But I'm pretty confident they were beguiled by a phony understanding of the founding era ideas about this, and believed that the Establishment Clause did not allow the government to provide subsidies, assistance, aid that flows to religious organizations, even under neutral law. That is, even if the program covers both religious and non-religious recipients, that the government is forced by the Establishment Clause not to provide the aid to the religious recipients. A couple of examples here might help to help you to see what's going on. The state of New York passed a provision that where the state would aid inner city private schools serving disadvantaged youth in various ways, including making grants for what were called maintenance and repair grants. That meant things like, electricity for lighting and heating, and from, removing asbestos, and, that sort of thing, maintenance. So basically some secular expenses of all private schools. Of course, it was already doing the same thing for public schools. So in a sense, what we're really talking about here is government services that go to all schools, whether they're public or non-public, private or religious, secular, private, all schools. And the Supreme Court held that was unconstitutional, because after all, some of that heating and lighting might be going to classrooms where there could be religious instruction going on. There might be prayers, there might be, if it's a Catholic school, very likely the courses would be tinged with a religious doctrine. And so they held, again, under that understanding that they had, based upon what they thought the founders intended, they held that violated the Establishment Clause. So in effect, what the court was holding is that the governments must discriminate against religious institutions with respect to the receipt of what would otherwise be generally available benefits. So that's Nyquist. The most extreme case was one that I had the privilege of arguing and losing in the Supreme Court in 1985. Actually, there were two related cases. The federal case was one based upon a provision that went back to the Elementary and Secondary Education Act of 1965. And this provided, where the federal government would provide grants to the local public school district to pay public school teachers to provide special tutoring, one-on-one teaching and tutoring to students who were both economically and educationally deprived with respect to reading and math, or basically arithmetic, reading, writing, and arithmetic. And so the very basics of education. And what these were basically as teachers in dealing with educationally troubled children. And so what they would do is they would go to the school, whether public or private, religious or secular, all schools the same. And the children who needed special help would be identified. These public school specialists would then pull the children out, either one-on-one or sometimes one-on-two or three, but basically in very small, the class would still be going on, but they would pull a few of the children out and then give them intensive assistance with this basic education. And the Supreme Court, and I had the privilege actually of defending this program, and the Supreme Court held by a 5-4 vote, much to my actually I was very surprised by this, because I thought it was a bulletproof program. Note that no public money went to the school. The school was not relieved of any costs. The money did not go to private school, religious school teachers, went to public school teachers. I mean, it was guaranteed to be secular in every possible way. but the court held that it violated the Establishment Clause because there was some kind of symbolic benefit to the school, and maybe the children wouldn't be able to tell the difference between government supported and privately supported, and maybe this is the most remarkable thing, maybe the teachers would be influenced by the religious atmosphere of the religious school into altering their teaching methods in a religious direction. I'm not really quite sure how tutoring, reading, writing, and arithmetic is done very religiously anyway, but the Supreme Court thought that could happen even if the teachers were trying their best to remain secular. So this was that was the high watermark of this what I call no aid view of the Establishment Clause. Now, let's put those two things together. And so if the Free Exercise Clause says that people like Thomas are entitled to generally available benefits, even though it in a sense supports their religion. If it weren't for his Jehovah's Witness faith, he would still be employed. But they cannot deny it because of his religious motivation for being unemployed. But parents who choose religious education do forfeit their rights to things like tutoring assistance because they made a religious choice. Now, I think if you think about that the two cases are just in flagrant contradiction, that the school tutoring case is a violation of the Free Exercise Clause as interpreted in the Thomas case. But the Thomas case saying that you have to give religious objectors unemployment compensation is a violation of the Establishment Clause as interpreted in the school case. I think that the Supreme Court had essentially made the two parts of a single constitutional provision at war with each other, right? Because if the Free Exercise Clause requires some sort of special protection for the exercise of religion and religion only, as it seems to, but if the Establishment Clause forbids any government assistance to religion, well, presumably protection is a benefit. So the Free Exercise Clause violates the Establishment Clause, and the Establishment Clause violates the Free Exercise Clause, at least as these two things had been interpreted by the Supreme Court. Right now, I think all of this is just this is a self-inflicted wound, as far as I'm concerned. This isn't what it isn't that the two clauses were at war with each other in their original meaning or in their genuine and meaning even today, but this is the product of the Supreme Court's interpretations. Well, there would be three logical ways in which this inconsistency could be resolved, right? The court could abandon its free exercise doctrine and say that that no longer is there any special protection for the exercise of religion. They could abandon, that's one possibility. A second possibility is they could abandon their Establishment Clause doctrine and say that it just is a misinterpretation of establishment to say that anytime the government assistance flows to religion, that's a problem. That would solve the problem too. Or they could reinterpret both. I mean, they might, and if they reinterpreted both, the practical effect of that would be to give the political branches, the legislatures, discretion as to, when they would extend benefits or burdens to religion in accordance with, in common with everything else. And, the free exercise clause would probably shrink to some sort of prohibition on active persecution of people because of their religion. And the establishment clause would be shrunk to something like prohibiting actual compulsion to attend religious services, belong to a religion, contribute to the church. So, and then everything in between, which is like virtually every case that we now have in modern constitutional law about religion, would just be left to legislative discretion. So those are three very different approaches. My personal view, which I'm not going to defend it right now, but if you wanted to talk about it in Q&A, I could tell you why I believe this, is that the court had gotten it right about the free exercise clause, but they had gotten it wrong about the establishment clause. And so what they should have done was revise their establishment clause doctrine and leave free exercise doctrine in place. So what happened between 1980 and today? Well, in 1990, in a very surprising decision, the Supreme Court abandoned its free exercise doctrine. This was a famous case called Employment Division versus Smith, but most of us in the real world can call it the peyote case. This had to do with members of the Native American church for whom ingestion of peyote, which is a kind of a psychotropic substance, is the central sacrament of the religion, somewhat similar to the bread and wine of Christianity. And these ceremonies are closely guarded. They don't let strangers wander in. They're done under carefully regulated circumstances that serve a lot of protection. That is, and there haven't been, and in fact, studies, if you believe studies, and there are some studies I think that should be believed, indicated that participation in the Native American church, far from being associated with the usual problems of alcohol and drugs, actually were the opposite, that the mental health and lack of substance abuse and so forth were associated with participation. You can believe that or not. It's really a policy question, not about the meaning of the Constitution. But in any event, the Supreme Court held that since the laws against peyotes on the list of controlled substances in the Controlled Substances Act, it's illegal for everybody, and the free exercise clause should no longer be interpreted as it had been in cases like Yoder and Thomas to require the government to allow the practice of religion in the absence of a compelling governmental interest. Now the court held that if the law, so long as the law doesn't itself single out religious uses for special prescription, that if the law is neutral and generally applicable, that it does not violate the free exercise clause. So no further inquiry into the magnitude of the impact on religious practice or into the seriousness of the government's interest in enforcing the law. So that was Employment Division versus Smith. there've been some qualifications to that since then, but it still, Smith remains good law. If you read the newspapers, you will know that earlier that the Supreme Court very recently was considered a case called Fulton versus City of Philadelphia about requiring Catholic social services to include unmarried couples and same-sex couples to give them their approval for adoption services. And the Catholic Charities won the case, but the big question had been that they had argued that Smith should be overturned. That Smith was a misinterpretation of the free exercise clause, and the Supreme Court did not answer that question. The Supreme Court said, well, the Catholic Charities wins in this case for a variety of reasons, sort of technical detail reasons, but we don't have to decide whether to overrule Smith. So Smith is still in place. It's one of the big questions in First Amendment law, whether Smith should be kept or not. Well, what about the Establishment Clause side of it? Here, there wasn't one decision. There were a series of cases. So the case I described having to do with the federally funded tutors in disadvantaged schools was 1985. Very soon after that, 1988, we had a case involving a blind young man who was entitled to a scholarship under the disability programs of the state of Washington. He was entitled to a scholarship to study in any program that would lead to employment. Well, Larry Witters wanted to study for the ministry. And so he was going to attend a religious college, as basically a seminary, and study for the ministry. That met the terms of the program, but the state said, no, we're not going to allow you to use your scholarship in that way. You can't have the scholarship if that's what you're going to do, because it would violate the Establishment Clause even though it's neutral and generally applicable, it's neutral between religion and non-religion. That isn't what matters under Supreme Court precedent. Any benefits to religion are unconstitutional, even if neutral. Those were the cases I described a bit ago. And the Supreme Court kind of looks at that and they say unanimously, big surprise in this case, but unanimously in an opinion by Justice Thurgood Marshall, who had been a pretty strict separationist, they say, no, the Establishment Clause can't mean that. It doesn't establish religion to give scholarships to everybody, to people on a neutral basis and let them choose. Establishment Clause is about, government forcing people into religion. It's meant to be neutral. It's not meant to be hostile to religion. And so Larry Witters won. And then the next case involved a deaf high school student, hearing impaired high school student, who was entitled under the federal Individuals with Disabilities Education Act to the services of a sign language interpreter. And the government said, no, you can't do this because you're attending a Catholic school, and it wasn't so much that it would benefit the school as that because of the religious school environment, the service would advance religion directly. Why? Well, the sign language interpreter would interpret everything that's going on. And, hey, they might have prayers, and the sign language interpreter would be signing the prayer, and they might be have religious teaching in this Catholic school, and the sign language interpreter would be conveying that religious teaching to the student. And we can't use the Establishment Clause doesn't allow the government to, pay for things that have this sort of direct way of advancing religion, even if the program is perfectly neutral. And the court looked at that, and they see this hearing impaired young teenager, and they say Establishment Clause can't mean that. It's a perfectly neutral program. All hearing impaired people are entitled to sign language interpreters, and the sign language interpreter is not adding, the government funded person here in this case is not adding to the religiosity of it. It would be just like if you gave the kid a hearing aid, right? It's just a human version of a hearing aid. And so the court said, no, the Establishment Clause can't mean that. And then come a case, I happen to be the counsel on the next case I'm going to describe, where some students at the University of Virginia, which is a public university, started a school publication where they were going to address, various things, movie reviews and interviews with faculty and articles on various things from a religious Christian point of view. Well, the University Student Activities Fund, I assume you have one here at UC Colorado Springs, a Student Activities Fund, and they dole out money to student publications. This publication met all the requirements for that. And they're not supposed, under the terms, they're not supposed to be discriminating against publications because of their viewpoint. If you want to be a communist, or if you want to be whatever, you have to be treated the same way. But this university said, but not you, religion is a perspective that we don't have to treat equally. And the Supreme Court looked at that and heard my argument. I hope I was persuasive, and by a very narrow, this is a 5-4 decision, they said, well, under the Free Speech Clause, government can't discriminate on the basis of, with respect to private speech, can't discriminate on the basis of viewpoint, and the Establishment Clause doesn't lead to any different conclusion, because as long as the program is completely neutral, everybody's treated the same way. It doesn't convey any endorsement. It doesn't advantage religion over non-religion. It's just neutral. And so that's how that came. Well, note, by the time you're getting to this, all of the intellectual underpinnings of those cases that I described have been abandoned, because those cases I described did not hold. In fact, they rejected the argument that aid programs, just because they're neutral between religion and non-religion, and where the religious choice is being made by the individual, that didn't save those programs. What the court was focused on was, does any of the aid, flow to the benefit of religion? And if so, it was forbidden under the Establishment Clause. Well, we've now had 3 cases in a row where allowed program is neutral, made by the individuals. It didn't matter anymore that, in fact, religion benefited, because the government wasn't the one who was choosing to benefit religion. There's one more case that I also Helms, but I'm going to put it aside for a second. It was another involving the provision of, this is a federal program that provided schools with an economically disadvantaged circumstances, computers and library books and a few other things. And again, so the lower court had said, no, you can't. Somebody sued saying you can't do that, and lower court had said, we don't think this makes a piece of sense. In fact, the lower court decision, the Fifth Circuit decision, called the decisions in this area a vast, perplexing desert. And so the judges said, we think this is wrong, but Supreme Court precedent forces us to say that it's unconstitutional for a religious school to, even though they're in the economically disadvantaged area, and even though, the library books are secular and the computer is a computer, in the argument I described having a computer as being the equivalent of giving the students a library card to every library in the world. How can that be an establishment of religion? So the Supreme Court agreed with that too. And then finally, in the early 2000s, the court basically scrapped the old doctrine. This is in a case about vouchers to schools in inner city Cleveland. Cleveland, like many large cities, had an absolutely catastrophically bad public school system with dropout rates over 40% and test scores in the basement, and parents were desperate for an alternative because obviously nothing was going to happen. And the state of Ohio said, well, we'll pay for vouchers to help a certain number of impoverished families get an alternative to these terrible public schools. And then the Supreme Court said, yeah, that's fine. It's as long as the program is neutral between religion and non-religion, and the choice of a religious alternative is being made by the individual and not by the government, it's constitutional, and all these old cases are gone. So the Supreme Court had come a long way, right? And had reversed those decisions that I was describing. This was early 2000s, so it took them just over 20 years from 1980 to do that. But that wasn't the end of the matter, because a lot of states still said, no, we're still going to discriminate against religious schools, partly because of a lot of 19th century state constitutional provisions that had been added at a time of anti-Catholic bigotry. We could get into that if you're interested in the details, and for a variety of other reasons, including the economics of public sector labor unions. A lot of states were still discriminating against religious schools, and now the religious schools are fighting back, and they're saying, well, everybody now agrees that the Establishment Clause doesn't forbid giving us aid, but why doesn't the Free Exercise Clause require giving us aid? Back when the peyote case came out, they abandoned the idea that you get to practice your religion in the absence of a compelling governmental interest, but they still said that the government couldn't discriminate, they couldn't single out religion for disfavorable treatment. Isn't that exactly what is happening? And the first case to make it to the Supreme Court under this new theory was the Trinity Lutheran versus Comer case. The state of Missouri had a bounty for discarded automobile tires. This is really an environmental measure. So, old rotting rubber tires aren't just sitting around in waste dumps on the side of the road. And so anyway, so bounty for tires. And then what they would do is use those tires to provide rubberized surfaces for playgrounds. Well, they didn't have enough tires to do that for every playground and daycare center in the state of Missouri. So they looked at various criteria like, how many children do you serve? Are they low income? I don't actually remember what all the objective criteria were, but none of the criteria had anything to do with religion. And Trinity Lutheran Church operated a very successful and popular daycare center, and they applied for a rubberized playground surface, and I think they were like ranked number 5 out of 20 or 30 recipients that year. But the state said, no, we can't rubberize your playground because although the Establishment Clause would allow us to do that, state constitutional law prohibits anything that benefits religion. And it would benefit religion for us to provide a rubberized playground surface for a daycare center owned and operated by a church. That gets up to the Supreme Court, and in a 7-2, which is a pretty large majority opinion, the court said, no, that violates didn't you read the peyote case? That violates our principle that the government can't discriminate against religious uses in a way that disfavors them. And since the Establishment Clause is fine with this and it's discrimination, this is unconstitutional. So 7-2. So Justices Breyer and Kagan, who often are strict separationists, joined with this. So powerful did the argument seem. So only Justices Ginsburg and Sotomayor dissented. But there was still some ambiguity here. Rubberized playground surfaces are like really secular. What about forms of aid that might be less totally secular than that? Like, how about tuition for parents, and where the tuition dollars then get spent on everything in the school, including the religious instruction? And so the next case, Espinoza versus Montana Department of Revenue, involved a scholarship program for I believe it was again low-income families to go to the school of their choice, totally neutral, except that the Montana bureaucrats said no to the family that wanted to use their scholarship to go to a religious high school. They said, no, we can't do that because under our state constitution, that would benefit religion. Gets up to the Supreme Court, and the court holds that that it violated the Free Exercise Clause. And thus all those state constitutional provisions that require discrimination against religious schools are effectively now unconstitutional. There's one more case up this year. I'm running out of, I want to stop talking, so I'm not going to describe it, but that takes this doctrine a little bit farther. But I ask you now to reflect on how far we have come, because back in 1980, the court was saying to states, you cannot have neutral aid programs, or if you have a neutral aid program, you cannot include a religious institution. Then for a while they said, well, yes, you can, but we're not going to tell you you have to. But now, after Trinity Lutheran and Espinoza versus Montana, what the Supreme Court was saying back in 1980 was constitutionally required. The Supreme Court is now saying in 2020, 2022, that that's unconstitutional. I don't know any other aspect of constitutional law where the Supreme Court has repudiated such a long line of cases that seemed firmly entrenched and so complete a U-turn as that. Now, I'm happy about that because I think that the Establishment Clause was never intended to require discrimination against religious uses. I think it was a neutrality provision from the get-go. And I believe that the purpose of both the Free Exercise Clause and the Establishment Clause is to maximize the freedom of every American, whether religious or atheist or secular, to maximize the freedom of every American to choose to have the religious beliefs that they find convincing and to live the kind of life that those beliefs would dictate, unless, of course, what they're trying to do is is in violation of some very important compelling governmental interest, in which case the claim of the freedom will be overborne. But the idea that their choice of, say, educational institution would be denied just because they take their consciences are oriented to religious faith was, I think, the opposite of what the First Amendment was really intended to mean. And I think the Supreme Court has come enormous direction and is basically its doctrine, especially under the Establishment Clause, has been corrected. And so it's a happy story. And now I'm going to subside while we still have time for questions and disagreement. People may want to jump up on top of their Zoom chairs and argue with me. That would be nice too.
Well, thank you, Professor McConnell. So I know we do have some questions coming in, and as I think I told you before you started, that there are some questions from some friends of yours in the community that I might pass along as well. But I'm going to exercise
Martin and Andrew, hello.
Yeah. I don't think they're on, but they're going to listen to the recording. So I'm going to exercise my prerogative as the moderator to ask a couple of questions to start off. One would just be on the Lemon test. I know I have a lot of students who are on this and former students who have heard about the Lemon test. In your view, is the Lemon test now completely put to rest, or is it dead? Or, as Scalia famously said, is it going to rise from the grave and shuffle abroad like some kind of monster from a late night horror show? So that's one question. A second would be related to the
well, why don't we do one at a time?
Okay, sure. Yeah.
Or I'll forget what you're asking. So first of all, let me situate the Lemon test in what I was talking about. Those Establishment Clause cases, like the one about the school not being able to get electricity and heating and maintenance grants, and the one about not allowing tutors to go into Catholic or religious schools to provide assistance. Those were decided under the Lemon test. Those are the fruits of the Lemon test. The Lemon test has three parts. One is that the governmental program has to have a secular purpose. In the school aid context, that has never played a part. The court has agreed that all these school aid programs have the secular purpose of trying to educate, assist in the education of needy children, and maybe to equalize resources to families attending public and private schools. The second part of Lemon was that there must be a quote primary effect of not advancing or inhibiting, but there was never an inhibiting case, or advancing, not advancing religion. And then the third was that there can't be excessive quote entanglement between church and state. Well, in Lemon itself, the effects part was interpreted in the context of aid to schools. And Lemon involved a state program in Rhode Island and Pennsylvania that provided salary supplements to teachers in private schools in low-income areas. This is a 1971 case. This is what happened. Just to give a little political or economic background here. This is the very height of the baby boom. The public schools are massively overcrowded. Meanwhile, Catholic schools, which have been providing, they're by far the largest school system in the large cities of America, including low-income areas. So we're not talking about Phillips Exeter Academy here. Phillips Exeter doesn't help people in the inner city. It's St. Margaret's that helps people in the inner city. But Catholic schools are going under because partly as a result of the women's movement, there aren't any nuns anymore. And so the low cost teacher supply of smart women who are willing to, teach for almost nothing, that's almost completely gone. Now they're having to hire teachers in competition with the public schools. Their costs are soaring. Meanwhile, wealthier Catholics are leaving the inner city and moving to the suburbs, so you don't have as many contributors. The economics of the Catholic schools in the big cities are catastrophic. And as they close down, those kids then have nowhere to go but into the already overcrowded public schools. And so states are coming to, meanwhile, and the public school systems are also increasingly of poor quality for a variety of reasons. And so state legislatures are reaching two conclusions. One is that they can save money. If they can just give the Catholic schools and other religious schools in the big cities enough money just to keep them open, right? They don't have to pay for the whole thing, but just keep them afloat. You're going to save a bunch of money, because otherwise you're going to have to pay the full cost of education for the kids who flood into the public schools. And secondly, let's provide a better alternative. By this time, Catholic schools were recognized as providing in many cases, lots of studies of this, the Catholic schools and other religious schools in the cities, although most of them are Catholic, are doing a better job than the public schools. They're better racially integrated. They are and they are doing a better job at delivering a quality education than the public schools are. So let's give parents an alternative, give families a way out. So anyway, that's why during this period there were just states, especially in the Northeast and the Midwest, urbanized states with significant Catholic populations, are passing any number of creative forms of aid to the schools, and the Supreme Court is shutting that down. And in Lemon, the two requirements effects, the court held that the state has to be certain, as their word, that there is no religious, they use words like intrusion, indoctrination, no religious element to the publicly funded activity. So if you give a salary supplement to a teacher, you have to be certain that that teacher isn't like introducing religious stuff into his or her teaching. Footnote, teachers in public schools have been known to introduce a religious element. And nobody ever said that we have to be certain that doesn't happen. But in the private schools, yes, so certain. But then they, in order to be certain, the state has to put into place a regulatory system which monitors, the word Supreme Court in Lemon uses the term monitoring and surveillance. You basically have to have a mini police state to watch after the teachers and keep their eye on them to make sure that no religion is creeping in to what they're doing in the school. And if you don't have a thorough monitoring and surveillance, you're going to lose under the effects test. And if you do have thorough monitoring and surveillance, that's going to be excessive entanglement. That's the holding of Lemon. That and has that gone away? That is now gone. That's what was eliminated. And I mean, when the introductory cases like Witters and so forth, but in the Cleveland voucher case, that went the way of the dodo. And so now the three-part Lemon test was then being applied to lots of things other than school aid. And there are probably about 6 or 8 sort of sub fields like accommodation of religion, religious symbols, legislative prayer. There are a whole bunch of specific issues where once upon a time, the court was using the Lemon test. The Supreme Court itself has not applied the Lemon test for 15 years. Is that dead? Well, it still has not uttered the magic words, Lemon is overruled. But in the most recent case, which was a religious symbol case, the court came exceedingly close to that. And so if Lemon is not dead, it is hanging by almost imperceptible spider webs.
All right, very good. Question from a student here. How would you define and interpret the word respecting in the Establishment Clause?
Actually, that's something that I feel pretty confident about. I was afraid you were going to ask me what religion means. And that is a really hard question.
Well, that was actually my second question, but I'll hold off on that.
But respecting, the word respecting came in for a very specific reason, that at the time of the Establishment Clause of the First Amendment, roughly half of the states still had some form of established church. By this time, it wasn't a single established church. It was what we call multiple establishments. Basically what would happen is that everybody had to contribute to and perhaps attend a church, but if they didn't like the majority church, they were free to attend the church of their choice. But that is a kind of establishment. That's compulsion. That's not consistent with a disestablishment principle. But about half the states had some version had that or some softer establishment, and they liked it. They didn't want to give it up. And so when the Establishment Clause was proposed, it was going to apply just to the federal government. And Madison's original proposal was to add an Establishment Clause to Article 1, Section 10, which only applies to the federal government. Well, for complicated reasons, Congress decided that instead of doing it that way, we would have a freestanding Bill of Rights at the end rather than sticking things in places like Article 1, Section 10. And so now it wasn't so clear, and the original draft said, there were various versions, but they would say something like, no establishment of, there shall be no establishment of religion. Well, the leading complaint in the House of Representatives was, hey, that could hurt our own state establishments. And we don't want to do that. And they went through various formulations, and then behind closed doors, they must have done some rewriting, because when it comes back, they said no law, it had been no law establishing religion. Now it says no law respecting an establishment of religion. And what that means almost certainly is Congress, the federal government, can neither establish religion, that would be a law respecting an establishment, nor disestablish religion. Basically, it was a federalism provision, leaving the question of whether to have an establishment or what kind of establishment to have entirely to the states. Congress has no authority with respect to establishments. Now, you might ask, well, why then does the Establishment Clause now apply to the states? And the answer to that is not the First Amendment, but the 14th Amendment, that after the Civil War, the Constitution was amended and the individual rights provisions of the Bill of Rights now apply to the states as well as to the federal government.
So a follow-on question from this, it actually comes from a colleague of mine, but it relates to this question of incorporating the Establishment Clause, because as you've described it, it was really a provision to protect states, status authority is what it sounds like. So the question is, based on your understanding, how does the originalist view of the free exercise and Establishment clauses relate to the doctrine of incorporation? So that is, did the authors of the Bill of Rights think the religion clauses of the First Amendment could be used to overturn state and local laws, or perhaps the authors of the 14th Amendment, and then in addition to acts of Congress, or did they only apply to the latter as the language of the First Amendment suggests?
The First Amendment only applied to, in fact, the entirety of the Bill of Rights only applied to the states, but establishment was especially sensitive about this, and that's where the respecting language comes from. Incorporation is entirely a product of the 14th Amendment, and there are various ways one can argue about this, and people still do. This is not, originalists disagree among themselves about the question that was just posed. So one question is, does any of the Bill of Rights apply now to the states? And then the second question is, even if most of it does, what about the Establishment Clause? Isn't that special? So as to the first question, I think a good majority of originalists believe that the answer that incorporation is a legitimate interpretation. What the Privileges or Immunities Clause of the 14th Amendment says is no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, that may not be entirely clear, but in both the Senate and the House of Representatives during the debates over the 14th Amendment, leading advocates pose the question, well, what are these privileges and immunities? And some of them would actually read from the Bill of Rights. Now, what they didn't actually read them verbatim, and so what they said about religion was they usually just referred to religious freedom or religious conscience. So they didn't specify, they didn't distinguish between free exercise and establishment. Well, today, the Supreme Court has gotten around to the idea. What happened is the Supreme Court incorporated these sort of selectively, beginning with property and free speech, and gradually, the most recent one was just a couple of years ago, which was the excessive fine clause of the 8th Amendment was the most recent, and gun rights have been fairly recent. So the second, now the interpretation is, except for a couple of them that have specific reference to the federal government, all individual rights protected by the Bill of Rights now apply to the states as well as to the federal government. I don't think even Clarence Thomas, who is our big skeptic about the Establishment Clause, I don't think he disputes that for the Bill of Rights in general. He certainly joined McConnell against City of Chicago, which had to do with gun rights. So is the Establishment Clause an exception? No law respecting how do you incorporate that? It's a federalism provision. Well, I don't think I think you can. And this is the way I look at it, that what the respecting language did is it forbade Congress from doing two different things: establishing a religion and passing laws disestablishing state establishments. By the last state establishment was abolished, it was Massachusetts in 1833. By the time of the 14th Amendment, there hadn't been a state establishment for decades. And the prohibition on federal establishment is an individual rights provision. It means such thing. I mean, if you look at Jefferson's bill for establishing religious freedom, no person may be compelled to attend or support worship. So it means other things than that too, but that's sort of its core, is religious participation is voluntary. That's an individual right. It's perfectly simple and logical to incorporate that, right? And what about the second half of it? Well, you can't incorporate that. It's illogical and silly, but it also doesn't really matter because there wasn't a state establishment anymore. So what is incorporated, and I think correctly so, is the federal prohibition on compulsion of participation in religion is now applies to the states as well. Now, the Supreme Court didn't come to that conclusion until 1947. So, but they're slow.
Yeah. All right. So I better get to one of the questions from one of your friends here in Colorado Springs. I'll just identify as a question from Martin. And this is a controversial one, but Attorney General Barr gave a speech last year in which he argued that critical race theory, as practiced in some public schools, functions like an establishment of religion. Do you think that it can constitute an establishment of religion?
Well, no, I don't. But I don't think Attorney General Barr meant, I don't think that's what he said. I was actually there. I heard.
Oh, okay. So we can get the direct story from
what he says, it functions like an establishment of religion, but it isn't religion. I mean, there are a lot of political doctrines that people believe with the kind of fervency that they might believe in religion, but critical race theory isn't a religion. There's no right to free exercise of it, for example. It's a political ideology. Now, I agree with Bill Barr that that some of the same reasons that make us convinced that religious ideology should not be imposed by the state on all the people. We are a diverse people. We believe different things. It's not proper to use state power to, I mean, another Supreme Court decision, Pierce versus Society of Sisters, says that it's contrary to the fundamental theory of liberty on which the nation rests for the government to standardize its children. So the point here is not that there's anything particularly wrong about critical race theory, but that the government should not be using the public schools to impose any particular ideology, whether it's critical race theory or capitalism or, environmental, that the schools should, they should acquaint students with, knowledge about issues, which would include the issues raised by critical race theory or capitalism or anything else, but that they should not go the next step and use even soft coercive means to get the students to believe in the doctrine that's being taught, right? And so I don't actually know what's going on in the high schools, but there are reports, that students are required to to do things like, identify their white privilege and so forth and so on. That's no different. I mean, it's not covered by the Establishment Clause, but it is a similar thing, to requiring them to recite a prayer, right? Not unconstitutional under the Establishment Clause, but it may very well be, as the Supreme Court said in Pierce versus Society of Sisters, contrary to the fundamental theory of liberty on which our nation rests. But I do want to emphasize again that this it's not because there's something about CRT that is offensive. I mean, it's not my particular ideology, but there's nothing about it's that any ideology should not be made the official doctrine. Another Supreme Court decision, West Virginia Board of Education versus Barnett, said, that there's, I wish I could quote it exactly, but there's no a brighter star in our constitutional constellation than the idea that the government may not make any doctrine, may not impose any orthodoxy on matters of, and then it goes on to say politics, religion, nationalism, or anything else. Well, I think CRT is covered by that.
Be covered by it. All right. Question on Carson versus Macon, which you alluded to. So do you think that the status use distinction that was articulated by the First Circuit, but it was also mentioned in the Trinity Lutheran and Espinoza by Chief Justice Roberts, has any basis in the historical record surrounding the adoption of the First Amendment?
Before talking about the historical record, I'd just like to talk about logic. It has no basis in logic. I don't know what it means. I think it means absolutely nothing. I think it was just a form of words that the First Circuit used in order not to follow the clear holdings of Espinoza and Trinity Lutheran. It's true that the Supreme Court used the term, but in Espinoza, right after the paragraph where they say that this actually was about status and not use, the next paragraph says that isn't to say that this is a distinction that makes any difference. And I don't think that it does. And I don't understand why the law in Carson isn't about status. I mean, the Carson against Macon is this, it's a program that exists in rural parts of New England. It's a very old idea and where there are districts where there are not enough children to have their own public school, they nonetheless collect the property taxes, but they provide a voucher to the kids in that district to go to the school of their choice. That means they might be able to go to a public school in a neighboring district, or they could go to a private school wherever they want. And there's, but in 1980, the state attorney general, remember 1980? I began my talk talking about 1980. That's at when the Supreme Court was still interpreting the Establishment Clause in this way that they've now abandoned. Well, the state attorney general read those precedents and said, well, we can't allow, this is called tuitioning. That's the way we can't allow tuitioning to go to religious schools. And now the question is, doesn't that violate the free exercise schools? But it was religious schools. Why isn't that status just like, Trinity Lutheran or anything else? I don't, what makes something religious? Things are religious, have a religious status if they do religious things. That's the definition. Look at, say, what is a religious tax exempt, an organization under the 501c3 of the Internal Revenue Code? It's an organization that does religious things. Or if you want to look historically, you know, in Britain, as part of the established church, in order to hold certain high public offices, you had to be an Anglican. That sounds like status, Anglican status. But what made you an Anglican? The law said you were an Anglican only if you had taken communion in a Church of England church within the preceding 6 months and swore an oath that you didn't believe in transubstantiation or the authority of the Pope. Well, so status is defined in terms of action. So I just think the First Circuit's distinction it's not just it's historically nonsensical, but it's just flat out nonsensical.
And do you think the court is going to reject it based on your reading of the oral arguments? Or is that
I have been wrong so many times. I should really just throw my crystal ball in the garbage bin, but I'd be astonished if they don't reject it. It just all their recent cases have been moving in that direction.
Right. So this relates to another question then about voucher program that was started here in Colorado in Douglas County, but then was struck down for violating, well, it was a Blaine Amendment issue, appealed to the Supreme Court. Supreme Court didn't hear the case, and then a new school board came in and got rid of the voucher program. So the question is really about the future of vouchers, and I think also Blaine amendments. Is your reading that Blaine amendments will essentially be unconstitutional after Carson versus Macon, and then therefore voucher programs like what we had in Douglas County, there would be no obstacle, at least under those provisions of state constitutions?
Yes, in fact, I think they are unconstitutional under Espinoza. Now, the Montana provision wasn't technically, I think they, for some reason, they don't call it a little Blaine amendment, but I don't care what they call it. If what the state constitution says is that aid can't go to religious schools or religious institutions, that is an overt discrimination, assuming they are otherwise eligible, of course. Religious institutions should not get any money because they're religious. They should get money if they satisfy the objective neutral criteria for aid under the program, and then they should get it notwithstanding being religious. And I think that's the holding of Espinoza. And I actually remember the Douglas County episode, and I think Douglas County was right then, and it ought to go back and revive this. And I think it's right on both constitutional and policy grounds.
All right. So with Espinoza, then Justice Breyer, who has announced that he's going to be retiring, he had a kind of a list of horrible things that would follow from the reasoning in Espinoza, that there was no real way to limit how far an otherwise available benefit would reach. How far do you think that goes?
So I think whenever the government is subsidizing private, meaning non-governmental organizations for the provision of public services, that they cannot discriminate on the basis of religion any more than they could discriminate on the basis of politics. So I just think, so some of the examples in Justice Breyer's opinion, I just think they aren't what they're just not what the majority is saying.
Okay.
I mean, there are plenty of doctrines in constitutional law where you have to scratch your head and how do you draw that line? I don't understand it. It's really vague. I don't think this is a particularly hard line to draw.
Okay. I think we have time for one more question, and it comes from a former student, but he mentioned that it might be a little bit off topic, but is interested in your experience as a clerk on the Supreme Court. And I know for many of our students who are in the audience, they'd be interested in this as well. So the question was, what kind of influence did you think you had as a clerk? But I'd be curious as to, in general, what kind of influence you think clerks typically have, or does it vary from one justice to another?
I think it very much varies, but I think clerks greatly exaggerate their influence in general. I think there have been justices that are maybe overly susceptible, but most of the justices, and I think probably all the justices that are on the court today are, they have very substantial, they're smart people, they have very substantial records. They've been around the block many, many times. The notion that these 20-somethings are going to be able to pull the wool over their eyes is, I think, we hear from the clerks, and then that's what they want to believe, but I don't, I just don't think so. In my year with a justice with whom I very frequently disagreed, but not on First Amendment issues, at least not free exercise and free speech, I think I might have persuaded him in two matters. There was one case on the merits where I think he was uncertain, and I think what I said might have pushed him over the brink. I don't know. It was actually an environmental case having to do with the relationship between federal common law and the Clean Water Act. And then the other was that he made his cert decisions himself. And there was one cert petition I had been watching, and I took it, walked into his office, presented it to him, told him that I thought this was a really important thing and why I thought so. And I don't know, whether I influenced, but I do know that he voted. I like to think that maybe I helped with that. It was a religion case, by the way.
Okay, all right. Well, wonderful. Well, Professor McConnell, thank you so much for taking some of your time to spend with us. We really appreciate it. Thank you all in the audience for joining us. Please do be on the lookout for the invitation for our next event, which will be coming up in March. So thank you once again, and have a great evening, everyone.
Thanks for having me.